Hi, folks, welcome. And we'll give it just 1 minute for people to be able to enter, and then we'll get started with the program today. Thanks so much for joining us. We'll be with you in just a moment. And for those who have just joined us, we're still admitting some participants, and so we'll just give it one more moment, and then we'll get started. Thanks so much for being here today. Okay, looks like attendees are starting to continue to trickle in, so we want to be very, very respectful of your time. So good afternoon or good morning, depending on where you are joining us today. Thank you very much for joining us. My name is Betsy Harned, and I am a vice chair for the Rights of Women Committee, which is a committee of the American Bar Association section of Civil Rights and Social Justice. It's a privilege to be able to welcome you today to this very timely webinar, Preserving Roe and the Rule of Law. I also serve on staff with the Planned Parenthood in metropolitan Washington, D.C., and we can't thank you enough, can't thank our panelists enough and you enough today to be here for this important topic. This program today is generously sponsored by the American Bar Association section of Civil Rights and Social Justice, and it's one of many programs that the section sponsors. We're actively planning additional programming, and we welcome you to participate. If you're interested, please visit americanbar.org/CRSJ for updates on upcoming programs. This program is also generously co-sponsored by the American Constitution Society's DC Lawyer Chapter and the Women's Bar Association of DC. Thanks to everybody. During today's programs, a couple of housekeeping items. We encourage you to ask questions, and we encourage you to do so through the Q&A feature. The chat feature is not going to be where we're able to do Q&A today. We won't be using the chat function, but please, if you have questions, we'll be able to turn to them towards the end of the program using the Q&A. Also, this program is being recorded, and a link will be provided to all registrants after the program, and we encourage you to disseminate it to your networks. And with that, I'm thrilled to introduce our panelists today. First, in no particular order, but first we have Dr. Bhavik Kumar. Dr. Kumar, thank you for joining us. Dr. Kumar is a current abortion provider in Texas who serves as a staff physician with Planned Parenthood Center for Choice, as well as Director of Primary and Transcare Services with Planned Parenthood Gulf Coast. We also have with us today Julie Rickelman, who is the Senior Director, U.S. Litigation for the Center for Reproductive Rights, and just argued the Mississippi case week before last in front of the Supreme Court. Thank you so much for joining us today. And last but certainly not least, to lead our conversation is Professor Michelle Goodwin, Chancellor's Professor of Law, the University of California, Irvine School of Law, and Director of the Center for Biotechnology and Global Health Policy, also at the University of California, Irvine School of Law. Before I turn things over to Professor Goodwin, I will note that among many, many distinctions, Professor Goodwin is an acclaimed bioethicist, constitutional law scholar, and prolific author. She directed the first ABA accredited health law program in the nation and established the first law center focused on race and bioethics. This is quite a distinguished panel. Thank you, everybody, for being here again today. And I will turn things over to Professor Goodwin.
Let's see. All right. Hope everyone can hear me now. It's a pleasure to be with you all, and I'm joining you from abroad, so I hope that we won't have any technical difficulties, or not too many. We couldn't be having this conversation at a more timely intersection in our country, and what I mean by intersection, many people are thinking about the future of reproductive health, rights, and justice right now, but I would urge that people are also thinking about and should be thinking about the future of the rule of law and the future of our democracy, the future of our constitutional democracy and what it means for civil liberties and civil rights. What we've been paying attention to in recent weeks, most people have been paying attention to these issues for many years, but what has come to the attention of many people in recent weeks have been matters of reproductive health, rights, and justice, and how the most vulnerable people amongst us are able to secure reproductive health care. And I'd like to set the stage in the brief time that I have for my remarks. And the staging that I would like to set is for us to understand that even Roe v. Wade, a 1973 opinion that was 7-2, not a close call at all, was a case that struck down laws criminalizing abortion in the United States. 5 of those 7 justices were conservative or Republican appointed. Justice Blackmun himself, who wrote that sterling opinion in Roe v. Wade, was put on the court by Richard Nixon. I set the stage in that way so that we can all understand that this should not be a matter of partisanship, how we understand reproductive privacy. In fact, in Planned Parenthood v. Casey, it's Justices Kennedy and Justice O'Connor, again, 2 conservative Republican-appointed justices who shaped the future of Roe v. Wade and ensure its longevity. I say that because the times in which we're in now and how these issues present before our federal courts, including the Supreme Court, is something far different than what we have seen before. And so let me set the stage just a little bit more, and then I'll talk about both Mississippi, the Mississippi case, and also the Texas case. So I want to set the stage even further because I think that it's a mistake that we talk about Roe v. Wade as actually being the starting point of thinking about reproductive health rights and justice or privacy in the United States. It wasn't. So that when we hear people saying, well, it's a close call and we really need to revisit it, we need to revisit Roe, it's important to understand that dating back to Skinner v. Oklahoma, the Supreme Court in the 1940s began articulating about the importance of reproductive privacy, autonomy, and that these were matters that were left to the individual, and that it was actually inhumane and a violation of human rights for the state to interfere in fundamental matters of when, how, if a person decides to become a parent. You'll remember in Skinner v. Oklahoma is a case that involved someone who was called a chicken thief, a person who was a petty criminal and committed petty crimes. And as a result of committing those crimes, the state of Oklahoma had determined that it could then sterilize those individuals against their will. The Supreme Court struck down such laws. What's interesting about those laws is that they made a stark difference between people who would commit petty crimes and those who would commit crimes that would be Wall Street related types of crime, white collar criminality. Fast forward from there, we have Griswold v. Connecticut, where again the Supreme Court is instantiating the importance of privacy and autonomy in reproductive health decision making and family planning. We have the case of Captain Kathy Struck, who's in the United States military in the Air Force. And the Air Force is insisting that she actually have an abortion before Roe v. Wade. She says, I want to carry my pregnancy to term and I'm willing to give my pregnancy up for adoption, the child that's born after the pregnancy. And the U.S. military, before 1973, before Roe v. Wade, says that no, in order to stay in the military, you must have an abortion. It's Ruth Bader Ginsburg who comes to her aid, and they fight the case over and over again until the U.S. military gives in. Of course, by that time, Captain Struck had already given birth and had surrendered the child for adoption. And then we have Eisenstadt v. Baird, which again, the U.S. Supreme Court, building on prior precedent, makes clear that the right to determine one's own reproductive future and planning is left to the individual. It's a case that strikes down a Massachusetts law that bars individuals rather than couples, so not like Griswold v. Connecticut, but individuals from being able to obtain contraceptive health care. And then we have Roe. And I would even say, even before that, to recognize the intersection of reproductive health, autonomy, and privacy and marriage. We have Loving v. Virginia in 1967, where the United States Supreme Court again speaks to these kinds of issues because the state of Virginia is claiming that Black people and white people shouldn't be married because those individuals would have children with disabilities, right? So again, there is a history and legacy and precedent even before Roe of instantiating the importance of privacy. Now, very recently, what we have is the kind of capstone, if you will, of a project that begins really in the 1980s and 90s with the targeting of poor Black women, poor brown women in criminal ways for the conduct during their pregnancy. And it is during that time that prosecutors and police are using the narratives of personhood in policing these women and dragging them out of hospitals in shackles and chains. And we see the legacy of that really capstone in these times, the Texas law SB 8, a law that bans pregnancy termination after 6 weeks, at a time in which people wouldn't even know that they're pregnant, women wouldn't know they're pregnant, girls wouldn't know they're pregnant, makes no exceptions in cases of rape or incest, actually allows for a bounty to be placed on the heads of individuals who aid or abet a person in terminating a pregnancy, providing the opportunity for those who would seek to stalk and search out and surveil and spy upon their neighbors at least $10,000 in potential recovery. It also provides for attorney's fees. The United States Supreme Court has allowed the law to stand while it is allowed at the same time for individuals to be able to sue certain state officials in the state of Texas. It is an alarming opinion. I urge you to read Justice Sotomayor's opinion and even that of Chief Justice John Roberts, who's been very concerned about the direction of the court and the rule of law. And then we have before the court the Dobbs case. It's a case that comes out of the state of Mississippi where there is only one abortion clinic that remains. It bars abortion after 15 weeks of pregnancy with no exceptions for cases of rape or incest. Both laws strike at the heart of Roe v. Wade, not only in terms of the threat overall to the ability to be able to make reproductive decision-making, but the Roe framework, which is kept alive by Planned Parenthood v. Casey. Now, as I wrap up, because I need to turn the stage over to Julie Rickleman and also Dr. Kumar, but let me say this. These times are also dire because when we think about the ability to be able to have a healthy pregnancy, terminate a pregnancy, the U.S. does an awful job on all fronts with the rise of the trap laws, targeted regulations of abortion providers, these abortion bans, even some of them named after civil rights leaders and abolitionists, which are really quite nefarious and quite ironic in so many ways. But let's be clear about who these laws harm and also the hypocrisy behind these laws. The U.S. leads the developed world in the rate of infant mortality and maternal mortality. If you go to the Central Intelligence Agency website, the CIA, you'll see that the U.S. ranks somewhere around 50th in the entire world in terms of maternal health and safety, after countries that have experienced genocide and war like Bosnia or even Saudi Arabia. That's where we rank. And the states that are considered, the places in the developed world that are considered the most dangerous to actually be pregnant and to carry a pregnancy to term, we're talking about Mississippi, Louisiana, and Texas. This is what makes this policy making so deadly, so nefarious, so unkind, so inhumane. And let me just close with the following thought, especially given that I'm about to turn the stage over to Dr. Kumar and also to Julie. In 1966, Dr. King received an award from Planned Parenthood. When he received that award, he wrote a phenomenal speech. And in that speech, he starts off with saying that if a group of aliens came to the United States, they would say that this is a country that is governed by insane men. He spoke of the urgency, the deep urgency of allowing women to be able to determine their own reproductive futures. He actually used the words of cruelty to describe what it is when a state forces people into certain kinds of reproductive futures that they do not want. Dr. King was keenly aware about what these histories and legacies mean for Black women dating back to slavery and then in the early parts of the 20th century with eugenics policies. I think we would be all wise to remember the urgings and the words of Dr. King. And I think it's worth remembering that these issues used to be nonpartisan types of issues. It's worth remembering that Prescott Bush, the father of George H.W. Bush, was the treasurer of Planned Parenthood. There's more that I could add to this conversation, but I think it's also important to turn the stage over to my colleagues. Dr. Kumar, and Julie Rickelman. And thank you all so much.
Dr. Kumar, do you want to go first?
Go for it, Julie.
Sure. I think I'm just going to give a brief introduction to the Center for Reproductive Rights. For those who may not know our organization, we are a nonprofit, nonpartisan legal organization, and we're actually the only global organization that is focused on reproductive rights issues. So we have offices around the world. We're a human rights organization, and the mission of the organization is to establish access to reproductive health care, reproductive rights as human rights that all governments are obligated to fulfill, respect, and enforce. So that's a little bit about the center. And I'm going to hand it over to you to introduce yourself, Dr. Kumar.
Thank you. I'm Dr. Kumar. I work at Planned Parenthood Center for Choice in Houston, Texas. And I grew up here in Texas, and I've been providing abortion care in the state for about 7 years now. I previously worked at Whole Women's Health, which was the lead plaintiff in the last Texas case that went to the Supreme Court. I've been traveling around the state providing abortion care here. Like I said, I grew up here, so I know what it's like to live here, and have been dedicated to making sure I come back where I grew up, where I know the towns and the people, and know the state and know how restrictive and aggressive they are on restricting abortion access. And being here not just to provide, but to also connect with the community and to make change and connect with the medical students and the residents, and to focus on what the future of abortion access and training looks like. I did not plan on learning as much about law as I did until I became an abortion provider in Texas, but I've been a lead plaintiff in 3 cases. One was a D&E ban, one was a case requiring fetal burial and cremation, and then there was a proactive case that is challenging all the currently enacted restrictions in Texas. And then in the last few years, there's been a couple of other cases that I'm not able to keep up with anymore. And the most recent thing in Texas that we've been, of course, navigating is Senate Bill 8, which has now been in effect for over 100 days. I think we hit 100 days last week. And every day, every hour that this law is in effect, we're navigating the care that our patients need and having to triage folks to go out of state. And it's just been a very catastrophic moment for us in Texas, and it feels like it's not going to get any better, unfortunately. So I'm happy to talk more about that and share some of the experience on the ground here as well.
Okay, with that said, then we're going to begin with a conversation today. And I want to engage Dr. Kumar and Julie in a conversation about where we are, what their thoughts are in terms of the Supreme Court and its recent order involving Senate Bill 8, as well as the oral argument in the Dobbs case. What do these issues mean on the ground for the people who are most affected? And so, Julie, I'm going to start with you. You were in the court. You handled oral arguments, and you did so masterfully, beautifully. So many people took to social media complimenting the way in which you handled yourself in front of the court. So many people were startled and stunned by some of the questions that you were asked by the justices. Since we have the benefit of having you right here with us, Julie, what was that like, that experience being before the justices? Did you expect this level of questioning from the justices?
Thanks so much for that question and for the very kind words. I really appreciate it. I'm just going to give folks a little bit of context just to make sure they understand this particular case, because as Dr. Kumar said, there have been too many cases. We've been trying to beat back too many restrictions. The attorneys, the brave providers who are willing to be plaintiffs. So this case, this particular Supreme Court case was about a Mississippi law, as Professor Goodwin said, that essentially bans all abortions after 15 weeks. And this is just the latest law that Mississippi has passed in the last decade. really longer to try and end abortion in the state of Mississippi through any means necessary. So as Professor Goodwin said, there's only one clinic left in the state of Mississippi, in part because of all of these restrictions that have piled up year after year after year. And so it is already, even under current law, is already very difficult for people in Mississippi to have access to abortion care. But Mississippi has continued to enact bans, and it enacted this particular ban, this 15-week ban, in 2018. And I think what's really critical for people to understand is that it did so with the hope that this would set up a test case to overrule Roe versus Wade. That was really the goal of the Mississippi legislature. And I want people to understand this is not the only law that was passed with this in mind. There are many bans that have been passed around the country, as Dr. Kumar was talking about, in many different states where legislatures had the goal to try and set up a test case to Roe versus Wade. But this Mississippi law ended up being the one at the court. So the law was passed in 2018. We were able to block it from the day it was supposed to take effect, so it has never taken effect in the state of Mississippi. Both of the lower federal courts struck this law down. They blocked it, said it was unconstitutional because it is clearly, flatly unconstitutional under current law. So the way the case got to the court, the first question when it first got there was really this question of, can you ban abortion after 15 weeks under current law? And again, the answer to that is clearly no, you cannot. The Supreme Court has said for 50 years, you cannot ban abortion before viability, and 15 weeks is at least 9 weeks before viability. So clearly unconstitutional. But during the course of this case being at the court, Justice Ginsburg died, and the court changed. And by the time I argued the case 12 days ago, really the key question that Mississippi was presenting to the Supreme Court was whether it should overrule Roe versus Wade completely. So not just permit a 15-week ban to take effect, but overrule Roe and say that states can ban abortion entirely if that's what they want to do. And that they're
If you can, just one moment on that, because you're hitting exactly the right points, and I just want to intervene with a question that goes along with where you're going, which is that Justice Sotomayor spoke to that. And could you describe what she was hinting at, even the terminology that she used, a term like stench? What was she getting at? And I think this is the direction that you're going in terms of how you're outlining the shift that represented Justice Ginsburg leaving the court and how Mississippi then reframed its argument.
Yes, absolutely. So at the oral argument, there were sort of three themes. And one of the themes was stare decisis, which is obviously the idea that the court isn't supposed to overturn precedent, especially precedent that has been around for 50 years, especially precedent that the court has itself reaffirmed, time after time after time. And you have to have a really, really good reason to overrule precedent in that circumstance, especially to take away a constitutional right. So Justice Sotomayor asked a series of questions, as did Justice Breyer and some of the other justices, about how could the court justify taking away this constitutional right, discarding 50 years of precedent. And that the way she put this, these were her words, not mine, was, would the court survive the stench of doing that? And that was her way of saying, could the court, in the public's view, really retain its integrity as a non-political institution if it takes away this right? And so that was a major theme of the argument because Roe versus Wade had become so central. And then I think the two other themes, to go back to your original question, Professor Goodwin, were trying to make the impact of abortion bans clear to the court on pregnant people, women, people of color. And that is what I and the Solicitor General for the United States, who was arguing in support of the right to abortion, that's what we were trying to focus on. We kept trying to bring the conversation back to the terrible health risks for women in the United States if they are forced to continue a pregnancy against their will. The fact that those risks are borne disproportionately by people of color. The fact that poor women already have so many obstacles to accessing abortion. That's why a 15-week ban disproportionately harms them. So we kept returning to what it would mean just at a very basic level to say, women don't have this right under our Constitution. And my argument was that we would never have equal status under the Constitution without this ability to control our health and bodies and lives, with the understanding that, of course, people other than women can also become pregnant. But so those were the themes that she, the Solicitor General, and I kept coming back to. But the court was really focused on stare decisis and whether Roe itself should be overruled. There were only really a handful of questions, largely from Chief Justice Roberts, about 15 weeks itself and whether this particular limit, this 15-week limit, makes sense or doesn't make sense. So I think I'll leave it there so that there's plenty of time for Dr. Kumar.
I'd love to find, you know, what we need is a week long of unpacking this American Bar Association. I realize that we get just an hour to do so, but it's an interesting test case in so many ways, the oral argument and what they represent, and what that represents in terms of the rule of law and the types of ideologies that we saw playing out during the space of those oral arguments. Dr. Kumar, I'd like to turn to you because you are affected and your patients are affected on the ground by what has, by the Senate Bill SB 8. So can you tell us a bit about what the impact has been? And also, I'm curious to know, what was it like for you? I mean, you paid attention to those oral arguments. You paid attention since then, and also with the court's order that it just released just a few days ago. So can you give us some of that firsthand on-the-ground accounting?
Yeah, sure. Thanks for that question. Well, you know, to take it back a little bit here in Texas, we've always said that Roe is the floor for us. Over the last decade plus, we've had every legislative session some new law or a couple of laws that are passed that restrict abortion in some way. So some of those things, and Professor Goodwin mentioned the trap laws that states pass, and we say this oftentimes in the South and the Midwest. So some of those laws in Texas are that there's a 24-hour mandatory delay, which means that patients have to come in at least 2 times for their abortion appointment. There's a requirement to have an ultrasound. It has to be the same physician that does the ultrasound that also provides the abortion, which sets up logistical challenges. Bans on using any kind of Medicaid, and then recently they passed a ban on using any kind of private insurance. So you either have to buy an abortion rider or pay out of pocket. And the number one reason we hear from our patients about why they need access to abortion is usually financial. And of course, we know that 75% of people who access abortion in the country are either poor or low income. And of course, the politicians who pass these laws know these things as well. We've been telling them as much as we can, and this is not news. And so that's the layering of some of the laws that are there. And then the last time that a Texas law went to the Supreme Court, the number of clinics in the state that provided abortion were cut in half. So we went from about 40 clinics to about 20. So that was all before Senate Bill 8 went into effect. That was all before COVID-19 happened. And that was before the Mississippi case, and the makeup of the Supreme Court looked very different. And so you can imagine that once you layer on COVID-19, the COVID-19 ban that Texas passed when the pandemic was first starting, where abortion was essentially just shut down in the name of COVID-19, even though it had nothing to do with that. We were sitting in the trauma of that, and then went into the change in the Supreme Court, the potential of Roe being overturned, and then just this past summer having Senate Bill 8 passed. And so we are traumatized, the folks that do this work. We are on edge. We have undergone a lot of change. We've undergone a lot of ups and downs. Again, this is not the first time a law has sort of made its way through the courts where a decision could happen at any point. And just logistically on the ground, we're seeing patients continue to need care. They're calling us with questions. Oftentimes they're coming to abortion care not knowing that there is any sort of restriction on it. They know that they're pregnant, they can't be pregnant, they want to make an appointment, get an abortion. What do you mean there's a 24-hour delay? What do you mean I can't use my insurance? What is cardiac motion? They don't understand these things because oftentimes it doesn't make sense. It never makes sense, right? And so we have to, on a whim, make changes in our schedules, our availability, how we're providing care, navigating, making sure that we're meeting the requirements of these new laws, deciphering what these laws actually mean, what does it mean for our patients, helping patients understand these things. And it's not just one thing, it's an entire web of these things, which is very, very difficult to do. So needless to say, this is a very trying time because we are exhausted just from the pandemic and getting through that, and then having to layer conversation after conversation with real human beings that we see who have names and are telling us about their families and the things that they're going through and why they can't travel out of state. It is very, very emotionally draining and difficult, just on a human level to sit in front of somebody And especially for me as a physician, knowing that I have the training and the expertise, I went to residency knowing that I wanted to get trained in abortion care and come back and provide that care here. And I can do that safely for my patient, a human being who's sitting in front of me, knowing that they can be pregnant, knowing it's in their best interest. But when you're sort of banned because of a law, and we're severely limited under SB 8, but of course, if Roe was to be overturned, and this is not a one state problem in the country and it becomes a 26 state problem, which is what will happen at minimum, right? Then the landscape of abortion access is just going to look very, very different across the country. And we have already heard from clinics in other states that it is difficult to keep up with the number of patients in Texas that need care, that they are scheduling patients several weeks out. And again, just thinking from a logistical perspective, if you are a clinic in another state, you're already taking care of patients in that state. And to have now hundreds of patients every week being dispersed throughout the country, and then having the urgency of knowing that those patients have traveled, have taken time off of work, that they need to get the care as soon as possible because they can't just reschedule for next week because they've just traveled hundreds of miles. It doesn't make sense, and it makes it very difficult for them to keep up. And again, if that gets extrapolated to half of the country, it is going to be very difficult for the landscape of abortion service to absorb the need that's there. And so it's very worrying, certainly hearing some of the questions from the Supreme Court about, what about adoption, which is just like mind blowing to think, from a healthcare perspective that, and especially coming from a person who's been pregnant before, that pregnancy is not a benign state. It has its own health implications. It has its own physical and mental health implications. There's a reason why we track maternal morbidity and mortality, right? So it was just mind blowing.
From death consequences, right? I mean, we know statistically that a person is 14 times more likely to die by carrying a pregnancy to term in the United States than by terminating it. And one would have to say, if we were talking about any other area of medicine, the government would say, why in the world would you choose that which could lead to your death by such a great margin? And we know that for Black women, they're 3.5 times more likely to die by carrying a pregnancy to term in the United States than by terminating it. And that only magnifies in certain counties where it's not 3.5 times, it's 10 times, 17 times, depending upon the county in the United States. I'm going to turn back to Julie, but just before I do, really quickly, Dr. Kumar, I'd like for us to spend just a brief moment on what's already been normalized in this space, because, the public hearing of Senate Bill 8 and could hear it as everything has been fine before, and now there are just these horrendous laws. But, what's been normalized is the harassment that's experienced daily at clinics, threats, assault. In the 1970s, there have been over nearly 50 bombings of clinics that perform abortions, arson, mass shooting, the killing of physicians. I mean, if this were any other movement, it would be placed on some list where we should all be concerned because of this high disregard for the rule of law that just simply seems to exist. And I wonder how that has affected how you practice medicine, how you practice healthcare, given that backdrop. Are you afraid ever?
Yeah, that's a great question. I mean, just looking out the window here at the clinic, I can see the protesters. It's a normal thing to have, or I wouldn't say normal, but it's a routine thing and a common thing, right? To have folks outside of our clinics. It's common to have fake clinics set up close by or right outside of our clinic. So again, I can see a blue bus that is a crisis pregnancy center. They often wear Planned Parenthood t-shirts. They harass us, they yell at us. Clinics have been threatened. For me personally, I'm pretty out there. My name is out there. My face is out there. I talk publicly about abortion because I think the benefits are greater than the risks. But this is the only place in healthcare where we see such violent harassment and attacks, where we have to think about wearing bulletproof vests, think about our security, have assessments on where we live, think about our children, think about our families, all of those things. And it's very unfortunate that that's part of doing this work. But again, for me, the benefits of helping people and knowing that we're making things better for people is certainly greater than the risk that it involves. But it is definitely unfortunate. And, we don't just see it in this country. We're also seeing some of the same tactics popping up in other countries. And it's something to note because I think, again, right now it's under the radar, but the same things that folks are doing here in the US is showing up in many parts of Africa, many parts of South America and Central America as well. And so these things are just being replicated. And, I'll just end by saying things that we've seen in Texas will not stay in Texas. And I think the agenda of folks that are part of these anti-abortion groups will continue to spread it throughout the states, will spread it throughout the country. They will not stop. It's relentless. And they have one mission, which is to stop people from having abortions, but also to oppress people. And that's part of their tactics, right?
So I want to turn it, thank you so much for that, because we don't spend enough time in our cultural dialogue, our legal dialogue about reproductive justice, health, and rights. You're speaking about what the kind of day-to-day is. And I have friends who are doctors who provide this very essential health care, and they're afraid to have their photos taken. They're afraid to be on video. They speak in very realistic ways about the fear of someone showing up at their door and shooting their children. I mean, this is not, when you think about it, I mean, that's just not outrageous for them to think about that. Within the mass shootings, the killing of doctors, the bombing of clinics, the setting of clinics on fire, those who would say, yeah, I went to school, I went to school in the United States, practicing something that is legal and constitutional, and I see my patients, I'm doing something that is constitutionally protected. But yet I have to fear being shot at my home or my kids being shot at my home when practicing this kind of medicine. And I think that it's not often enough that we can level set and speak to exactly what people who are doing here have to experience. And so, Julie, I want to turn to you because before I open it up to Q&A, what kind of future can we expect? What can we expect from the United States Supreme Court, and what can we expect from the lower courts? I'm so happy that you mentioned Judge Carl Reeves' lower court opinion in the Mississippi case, because it's one that I would so strongly recommend that folks read, and read the footnotes, because in many ways, what Judge Reeves did was a kind of build on to Justice Blackmun. If you consider that Justice Blackmun canvassed history so much more, so does Judge Reeves, as he talks about, well, let's think about and unpack the realities of Mississippi. Let's really think about how Mississippi has treated Black women. Let's reference Fannie Lou Hamer. Let's reference the Mississippi appendectomy. Let's look at what life has truly been when we think about whether we can take seriously this saying this is all out of care and concern for the women who become pregnant. So, Julie, what do you see as next stages, given that the threat of this in 26 states to people who can become pregnant, that Roe v. Wade may be totally gutted? Do you see it that way, or do you see some possibility and silver lining?
Well, I think it's really hard. I don't want to predict today how the Supreme Court is going to rule, but I think it is critical for people to understand what's at stake. And as both you and Dr. Kumar just said, if the court overrules Roe, there could be half the states in the country that will move quickly to try and ban abortion entirely. And that's just going to be devastating. Devastating for people around the country, for their families. There has been so much information that we've gathered over the past 50 years about what it means for people to have access to abortion, how it changes their lives. We know that if somebody wants to have an abortion but isn't able to, it means they're more likely to experience economic insecurity for themselves and their families. Their existing children do worse in a whole host of measures. They're more likely to stay with a partner who's violent. So it's just, completely devastating for people to be denied access to this care. And so we know that's what's at stake. If the court does overrule Roe, there are things that we can do. I think it's critical for people to continue to work at the state level and try and put into place state level protections wherever they can. There's a bill in Congress called the Women's Health Protection Act that tries to create a statutory right, as Professor Goodwin has testified. And it would mean that if there's no longer a constitutional right, there would be a statutory right that people could bring in federal court. But I think, just speaking more broadly as an attorney, I think it's just critical for people to really talk about this issue as an issue of not just gender justice, but economic and racial justice. And that is really what Judge Reeves laid out in his opinion. Professor Goodwin, he talked about what this really means for people who can't access abortion. As Dr. Kumar said, 75% of those people are poor or low income. They're disproportionately people of color. They're disproportionately already parents. This is going to harm poor families or families who are struggling to make ends meet. And it is part of a pattern of controlling the decisions to have a child, to not have a child, of people who have been marginalized in our society. So I think moving forward, that's how we all need to think about it and make clear really what the stakes are if this right is taken away.
All right, quick question for Dr. Kumar that comes from one of our audience attendees. Is there a way to donate to help patients who need to get health care out of state, but who do not have the means? And I can also open that up to Julie as well. There are abortion funds, but Dr. Kumar, do you want to speak to that?
Yeah, absolutely. You're right about abortion funds. So for folks that are looking to donate, there's a link, and I can find it and put it in the chat. But there's a link where you can donate to a collective of the abortion funds and practical support orgs. The abortion funds tend to help augment the cost of the actual medical care, and then the practical support orgs are helping with travel, lodging if they need to stay overnight, any sort of practical things, including food, airfare, anything that might be involved. And so they are certainly out there and helping people get there. And then there's also our Planned Parenthood Fund, where we're helping people get to where they need to go to. So, and just so folks know, when we do see patients here in the clinic, or if they call on the phone, we're trying to help them through the logistics of, where to go, how to get there, what they might need, and softening that experience as much as possible. But it can definitely be a lot, and it's nice to have that information, at least, so that they can, get to where they need to get the care that they need.
Dr. Kumar, another follow-up question with another audience about the misperceptions that are associated with pregnancy. That is to say that there's this presumption that all pregnancies are healthy, and that there's something of a perfect pregnancy. And this, in some ways, undergirds what we see in terms of legislative lawmaking. Can you unpack just briefly your perspective about why, in fact, that is actually very dangerous thinking from a legal perspective and a health?
Yeah, certainly from a health perspective, right? I think, pregnancy for each person can look different, and certainly people can have healthy pregnancies. Certain people can have healthy pregnancies where they're not very happy. Some people can have unhealthy pregnancies and be very happy. It's a very mixed and nuanced thing. But for me as a physician, at the end of the day, when I'm speaking with a pregnant person, we talk about risks, we talk about benefits, we talk about what it means for them to be pregnant. Do you want to be pregnant? What does this look like? And based on that individual person's risks and previous pregnancies, if they've had them before, we talk about what this could involve. And that can change throughout the course of their pregnancy. And if somebody decides that I understand the risks and I want to continue with this pregnancy, then that's their choice, right? We make that decision together. And certainly if something comes up with a pregnancy, and a healthy pregnancy certainly becomes less healthy than it was, and that person says, I don't like those risks anymore, I think I'd rather not be pregnant, we should be able to help them, so that way they can be there for themselves in whatever way they need to, or their families, or whatever they want to do in life. And so it's, what I would say is that it is individual, it is nuanced, and it is complicated. It is something that a healthcare provider should be talking about with a person, because it's not just as simple as healthy or unhealthy.
I'd like to turn to you. It's a question from our queue, and it comes up with a mention of the Women's Health Protection Act and the distinction between a constitutional right versus a statutory right. So if we're to follow what those who are most doubtful about the Supreme Court and what might be coming from the Supreme Court, a potential overturning of Roe v. Wade, and let's say that Congress does enact the Women's Health Protection Act, what would be the difference, in your opinion, from there being the constitutional right versus a statutory right to be able to terminate a pregnancy?
That's a great question. I think there's both a practical answer and a more legal answer to that. I think the practical answer is, maybe not that much of a difference, because the idea of a statutory right that exists around the country means that people will again have this right no matter where they live. And that's what would be missing if the court overrules Roe and Congress doesn't act. It means that people in Mississippi, Texas, Louisiana, the states that we expect to ban abortion very quickly, they just won't have this right at all, whereas people in New York and California may have it. So if Congress acts, passes the Women's Health Protection Act, it creates a statutory right that exists around the country that every person in every state can use to bring a lawsuit. But I think that's the practical answer. But the legal answer is, I do personally think, especially as a constitutional lawyer, that a lot is lost if the Supreme Court says that we do not have a constitutional right to make this decision. First of all, it's just devastating for people, as I mentioned, and for their families. But as Professor Goodwin laid out at the beginning, what does it mean about so many of the other cases? The court has said for over 100 years that people have a right to make decisions about their bodies, to bodily integrity. It has said they have a right to make personal decisions related to marriage, family, and childbearing. There's so many of those cases. This decision implicates both your right to control your body and your right to make that personal decision. If the court says we don't have it anymore, what does that mean for all of those other decisions? So there is a whole set of jurisprudence around this area, around the ability to control your body, to make these critical decisions. And I personally think it's devastating if the court says that right no longer exists under the Constitution, even though, of course, it is critical that practically people have it as a statutory basis.
Julie, let's talk a little bit of inside baseball and balls and strikes, given that we have your expertise, that we have you here. And I think it's also worth noting, just as a point here, especially as the ABA has been really committed to lifting women's voices and diversifying what it does, you're part of a very small cohort of women who have argued before the United States Supreme Court, and an even slimmer group that's argued before the United States Supreme Court this term. So thank you for the work that you do and the substance of what you do, but it's also worth noting that you're part of a very small club. So given this, that you've been able to have an inside view, sometimes it's been described that there's the calling of balls and strikes on the United States Supreme Court. And I'd love to hear your perspective about what you see from the justices, and part of this is a question in the queue. So what can we expect from Justice Gorsuch, perhaps? And I know, you don't have the crystal ball, but what's your intuition? Gorsuch, Kavanaugh, Barrett, Alito Thomas, Chief Justice John Roberts, and we've got the liberals, Kagan, Sotomayor, and Breyer. So what's your sense of these packs on the court?
Well, I'm sorry, I don't mean to disappoint. I don't feel comfortable predicting individual justices' decisions, but I can say this. So we know a number of the justices have already, been very clear in previous decisions and previous dissents, I should say, that they would like to overturn Roe versus Wade completely. They have already said that. We also know that a number of justices have voted repeatedly to uphold restrictions on abortion, even while the law has been what it stands today. Even while there has been a constitutional right, there have been many justices who, they voted to uphold the clinic closing laws. The case that Dr. Kumar was talking about out of Texas. Then I actually argued this same exact case 4 years later at the Supreme Court about an identical Louisiana law. That case could, as a lawyer, I cannot think of a case that should more likely have been 9-0, because the court had just said 4 years ago in the Texas case that the identical Texas clinic closing law was unconstitutional. So it was now looking at a Louisiana clinic closing law, same language. It should have been a 9-0 decision, but it was 5-4. So we know that there are justices who have voted to uphold abortion restrictions many times. And so I think the question really is, at this point, again, this should be a simple case. The court has said for 50 years, you can't ban abortion before viability. So this should be easy ball and strike to call. And I think if the court upholds this law, it is overruling Roe. I think it's critical for people to understand that by upholding this law, even if it doesn't use the words "we've overruled Roe versus Wade," that is what it will have done, because the court has said you can't ban before viability, and everyone agrees this is before viability.
All right, you basically answered a question that came up in the queue. Like, what about if the Supreme Court upholds the Mississippi law, but it doesn't explicitly say by doing this we're overturning Roe? What you're getting us to think about is what's the underlying substance, the substantive effects of these particular matters, and that's critically important. So, Dr. Kumar, I'd like to turn to you because people are concerned about what is the kind of messaging that should be done. And some people are concerned that what those who are anti-abortion have been able to do has been to control the narrative, control the dialogue in ways that are really quite problematic. I mean, even Senate Bill 8, its use of heartbeat when it weeks there is no heart, and so no heartbeat. But so much in media then follows the nomenclature that's found from the anti-abortion lawmaking. Have you, because you're on the ground, gotten a different kind of sense about the kind of language that should be adopted and used by those who care about preserving women's health, preserving people's health, preserving the health of girls who become pregnant? How exactly should those who care in that way message?
Yeah, I think that's the $1 million question, honestly, right? About how we talk about abortion. And of course, I'm not a comm specialist, but I do talk a fair bit about abortion and have these conversations, especially with the media. And, my general sense, both seeing patients one-on-one and also talking about it in the media and having these conversations is just, first of all, talking more about abortion, but talking about development, talking about what it means as something is developing, to talk about potential life, and to be more comfortable with that. I think our movement has very shied away from it and perhaps minimized a lot of these things, and I think it hasn't done us good. And I think a lot of people are uncomfortable to talk about potential life and to talk about what could be. And I hear that from my patients too, right? Like, sometimes they have names, sometimes they have thoughts about, if I did carry this pregnancy, this and that would happen, but they still go forward with an abortion. And it is complex, it is nuanced, it is mixed with different emotions. And those things are human, those things are normal. And I think we try to either make it good or bad, like pro-life or pro-choice. We try to categorize it and simplify it. And it's not that. And I think what the opposition has done is really played at the heartstrings of so many people by talking about a heartbeat, right? Talking about something that is allows people to connect with, and we can still connect with it, and we can still say that I'm going to terminate this pregnancy, I'm not moving forward, and still be connected with that, and that is still okay. We make hard decisions all the time, but I think we have a long way to go to have these complex conversations. But I do think we need to engage in it more in order to get people to understand how complex and nuanced and how much thought goes into people who do decide to have an abortion, and how much love they have for their pregnancies, but still know that they are making the right decision for them and their families. And those things are okay. Those things are normal. Those things are a moral good, right? So that's the direction that I would love to see this conversation go.
Julie, I want to blend one of my questions with that in the queue, which is what can be expected from Texas lawmakers, and really potentially 26 different states in lawmaking, if people in those states leave states to obtain their abortions elsewhere. Does that potentially raise any kinds of legal questions? Have you gotten a sense, any kind of hint that that's the next phase of lawmaking in states like Texas, elsewhere? And let's add on to this, because one of the persons who's our attendee today has added on, why are we not talking about places like New Hampshire and other places in the north that are engaged in similar kind of lawmaking?
I think that's a really important question, because we know, Dr. Kumar talked about what's happening in other parts of the world. We know what happens in other parts of the world when abortion is completely banned. And what happens is, again, people who are poor, struggling to make ends meet, people of color are hurt the most, and they are criminalized sometimes. So if states, even if states ban abortion within their borders, we don't know if they'll also try and say it's illegal for you to even try and have an abortion somewhere else. And they may not be able to do that. We should maybe be able to block that in court. That may be clearly unconstitutional, but prosecutors may go ahead and start taking actions. And so when abortion is banned, even every miscarriage may become a crime scene. People who have, a variety of pregnancy outcomes may be investigated. So it's incredibly concerning. because even if people are able to travel, which we know everybody can't, right? Some people will be forced to carry a pregnancy to term against their will, but even if people are able to travel and access abortion elsewhere, unfortunately, some of those people will be facing real risks of, criminal or other negative actions being taken against them, and that's incredibly scary.
There's a question in our queue, and I'd encourage any final questions to be put in the queue because we're going to be wrapping up soon. And again, we could spend much more time on this. I can't tell you how much I appreciate you, Julie, being on this call, and also Dr. Kumar. So in our chat, a question has been placed. Does Roe guarantee the right to bodily autonomy or just argue viability? Julie, what's your interpretation of how Justice Blackmun pinned that?
I absolutely believe that there is a right to bodily autonomy in the Constitution, and as Professor Goodwin started, it predates Roe. It's not just about Roe. It goes back to the 1800s. There are decisions going back to the 1800s saying that the most basic understanding of liberty in our Constitution is that you have to be able to control your own body, ideas of personal security. And so what Roe did was, again, it recognized that when you look at that already clear constitutional protection for controlling your body and you combine it with the decisions
I think that Julie froze just for a moment for us, but what she was saying, she's going to come back, but what Julie was saying is that there has been for centuries in United States jurisprudence and also in lawmaking, the principle, the value of the autonomy and privacy, liberty and freedom associated with the human body. Think about this, the Bill of Rights itself is very much centered about protecting individuals from the tyranny of the state, their ability to speak, their ability to be private in their own quarters, the ability to challenge government. Right in the First Amendment, the freedom is not just a speech, but it is actually to also petition government, to be able to freely assemble. We have the Eighth Amendment that protects individuals from the cruel and unusual punishment that could befall them by the state. There's so many areas within the First Amendment of our United States Constitution, and that doesn't even count the 13th Amendment, which abolishes involuntary servitude by the state or any private party, and as well substantive equality that we get from the 14th Amendment. It's a great question. And I'm hoping that we get Julie back as we turn to the final couple minutes. I do hope we get Julie back. But Dr. Kumar, a silver lining. It can be very hard in times like this to see anything that is hopeful, particularly given this conversation that we've been having about centuries of jurisprudence that upholds civil liberties and civil rights with regard to the body. And we know that's not always been the case for people of color. And now we see how it's been challenged. What do you see as a silver lining?
Oh boy, the silver lining. Well, I think what I'm holding on to in this time, again, being in Texas and doing this work here, of course, the silver lining is hard to find sometimes, but I think what I hold on to is knowing that abortion is not a current issue. It's not a modern issue. It's not a US issue. It's a human issue. And throughout time, people have always needed to end their pregnancies. And we know that. So right now, even though things are very difficult and complex with the way things are going, I know that we will prevail and that people will always need this care, and that we are not in the best position right now, but we will get there. And it's important for us to stand in that light, to stand in that truth, and to continue moving forward, because there are future generations that are depending on us for that right. So to me, that's the silver lining that I'm holding on to, at least.
And then just for a quick 30
so
seconds,
sorry, my
silver
internet
lining.
dropped.
I had your back, Julie. I had your back.
It.
But if you have a quick silver lining, a quick 30 seconds about, how you see anything positive coming from this time.
I think, just to echo what Dr. Kumar said, I think people sometimes when, the worst comes to pass, it makes people understand how critical something is. And I do hope that what this moment will show is how critical abortion access is for people's lives, and that people will be activated. And as Dr. Kumar said, in the end, we will prevail, and we certainly won't stop fighting, because this is a human right. It's something people need for their lives, and I fully believe that we will prevail in the end, even if it takes us longer than it should.
Thank you, Dr. Kumar. Thank you, Julie Rickleman. And I'm turning it back over to Betsy from the American Bar Association. Thank you, ABA, for hosting this webinar.
Yes, thank you. And I just hate to see this conversation come to a close. It was so robust. Thanks to each of you for your time and your unique perspectives and your thoughtfulness. I do want to lift up that in the chat is that donation link. Thank you, Dr. Kumar, for providing that. So for folks who are interested and able, please, certainly folks need the assistance. Thank you on behalf of the American Bar Association, specifically the Civil Rights and Social Justice section, as well as on behalf of the American Constitution Society's DC Lawyers Chapter and the Women Bar Association of DC. Thanks everybody for joining us today. We hope that you join us for future programs as well.